Good morning. Happy Sunday. Most recently, what's his name? Aaron Queen or something like that, who obviously won't understand what I'm talking about. So this isn't addressed to him. This is addressed to the people who are capable of learning. But I saw another person address the issue, something about in the Irish Demon issue, whether the United States Supreme Court was exercising like extraterritorial jurisdiction or some nonsense. So I figured I'd give a broad, high-level overview of the way jurisdiction works. In the court system, you're worried about two kinds of jurisdiction, generally speaking. You're looking at personal jurisdiction and subject matter jurisdiction, generally speaking. Subject matter jurisdiction is, does the court, if the allegations in the complaint or in the whatever document, petition, whatever the document is that got you in front of that court, do those allegations, if true, give the court authority to make a decision on that subject? For example, a lot of states have different courts, like they'll have a county court that hears high-level civil issues, and they'll have a lower court, like a magistrate court that'll hear like family issues, or they'll have one court for misdemeanors, one court for felonies. So if you try to bring a felony case in the misdemeanor court, that court would lack subject matter jurisdiction. And the court bases its understanding of whether or not it has jurisdiction over the allegations in the complaint or petition or whatever the moving pleading is. So if the moving pleading makes allegations that, if true, would give that particular court subject matter jurisdiction over it, then awesome sauce. The court can hear the case. The next issue is personal jurisdiction. Personal jurisdiction is acquired over the plaintiff or petitioner by the plaintiff or petitioner filing the particular lawsuit, complaint, petition, what have you. That is the plaintiff's essentially saying to the court, I am willing to have you hear this matter. I am submitting to personal jurisdiction. Now, the court, generally speaking, gets jurisdiction over the defendant either by having him appear in the court or by having him answer the complaint or petition, or by him being personally served, generally speaking, personally served, or there are alternatives, generally speaking, but by having him served with the process, with the summons and the complaint, or whatever the opening papers are. Once he's served, or appears, or files anything other than a document that contests the personal jurisdiction, or subject matter jurisdiction, or both, then once he does those things, then the court has jurisdiction over him. At that point, the court can make orders binding to him, or a judgment binding to him, until service is effectuated, or until he appears, or until he files some document other than a motion seeking relief on jurisdictional basis. Once he does that, the court can bind him. So subject matter allows the court to hear it. Personal jurisdiction allows the court to make a binding order over them. So that's the distinction between those two. Territorial jurisdiction is, generally speaking, not really a thing the courts deal with, generally speaking. Territorial jurisdiction is something that is more relevant to the state or federal government or country. For example, California can make laws, obviously, that affect California citizens, but it's a lot harder for them because Nevada is a separate sovereign to make a law that would affect Nevada citizens. It's much harder for them to do it. It's not impossible, but much harder. So territorial jurisdiction allows California to make laws to control the actions of its citizens and to protect its citizens within its territory. That's territorial jurisdiction. And like generally speaking, some exceptions apply. Generally speaking, law enforcement officers, like California state law enforcement officers or local or county law enforcement officers, don't have the power to make arrests in like Nevada. Now, there are exceptions because, for example, what if somebody standing in Nevada shoots at someone standing in California? Does California have an interest in that? Yes, because they have an interest in protecting their citizens from being shot at, even from someone on the Nevada side of the border. So California could work with Nevada to get that person extradited to California. Basically, they have to ask Nevada, give us this person who is in your territorial jurisdiction so that we can try him. Once California gets that person, it's no longer a matter of territorial jurisdiction. Once it gets into the court, it's merely a matter of subject matter jurisdiction and personal jurisdiction. Similarly, like for the Irish Demon example, or the fraud or troll example, they are citizens of and residents of different nations. Now there are a lot of treaties, but the big treaty is there's the HEG Convention. There's multiple treaties in the HEG Convention, and not all nations are signed up to all of the different conventions in the HEG Treaty, the HEG Convention. And each nation gets to write its own laws to implement their agreements in the HEG Conventions. But essentially, both of the nations both Ireland and Canada, to the best of my knowledge, are signatories to the relevant HEG Conventions, i.e. the HEG Convention on Service. I'm not sure about the HEG Convention on Evidence, but that might also be relevant depending. Now, essentially what those treaties do is those treaties allow citizens of other nations, as long as they comply with the terms of the HEG Convention and the laws enacted in the Ireland and or Canada, depending on where you're trying to serve the person, it allows citizens of other nations to sue your citizens in those other nations, providing they comply with the HEG Convention. And what that does is it allows the home nation, or the nation of the person who's being sued, to see the documents, to know what their citizen is being sued for, and if necessary, to step in and assert their own sovereignty in that particular lawsuit or criminal action or what have you. Not all nations, like I said, are signatories to this, so you can't sue anybody anywhere in the world at any time, but because these treaties are in effect, that gives a U.S. court that has subject matter jurisdiction over a particular lawsuit. It gives the plaintiff a ability to serve and to give the court the personal jurisdiction. And once all of those particular technical details are met, then the U.S. court can render a judgment. Now, enforcing the judgment again would require, unless the person who's being sued has U.S. assets, again, more compliance with HEG conventions to get the judgment enforced, assuming the person who is sued doesn't just willingly pay the judgment, which you'd be surprised at how often they're not willing to just pay the judgment. But you get the point. So does the U.S. District Court in the Northern District of California have subject matter over a copyright issue? Absolutely it does. It 100% does, because it is they're enforcing a U.S. claim. The complainants, the people who have filed the complaint, are U.S. citizens living in the U.S., so the actions taken by these foreign citizens have affected them, allegedly. And so the U.S. court has subject matter jurisdiction. Now, does the U.S. court have personal jurisdiction? Not until the person is served. I believe there was someone in Canada who was recently served, Raskin or Rankin or something like that. I'm not sure the name entirely. But they were, I believe, effectively served, and I believe they responded, but I could be wrong on that. I probably am wrong on that. I think there was a demand letter or an opposition to the demand letter sent or something like that. I'm not entirely sure. But anyway, if that person, well, let me just back out of that example entirely. If the person is properly served in Canada or in Ireland, then the U.S. court can make a judgment. Enforcing the judgment is going to be a different story. There is a doctrine called forum nonconveniens. And so if, for example, a person in Ireland is suing a person in Canada for violation of copyright laws, U.S. copyright laws, and they file in the U.S., the U.S. court could, on the theory of forum non-inconveniens, say, look, this doesn't involve U.S. citizens. Well, so actually, they wouldn't have subject matter jurisdiction in U.S. court. Let me take a different example. Let's say this was the example that was given to me in law school so many years ago. An airliner containing U.S. citizens crashes in Scotland. The family of the survivors brings an action in U.S. district court suing the operator of that airline, which is a Scottish entity based in Scotland. The U.S. court could say, look, well, technically these are U.S. citizens and they could bring this cause of action in federal district court. While we do have subject matter jurisdiction, and while we do have personal jurisdiction, it would be better, since the crash happened in Scotland, the witnesses are in Scotland, the survivors are in Scotland, it would be better to have this matter heard in Scotland. So what they would do, since they can't transfer the matter to Scotland, is they would dismiss the case without prejudice to allow the complainants to refile in Scotland. It's a fancy way of saying, technically you could bring it here, but really you should be bringing it in the court of a different country. That can also apply in the United States. If you bring a lawsuit in, say, California against a Nevada citizen, California could apply the forum of, or the doctrine of forum nonconveniens to dismiss the case, to have it transferred to Nevada. The doctrine of forum nonconveniens, generally speaking, doesn't apply inside of a court system. For example, if you file in the wrong county in California, it's not forum nonconveniens, it's just a transfer of venue. So the case isn't dismissed, it's transferred. For example, in other states where you bring a case, let's say the state brings a case as felonies and misdemeanors in a court that can hear felonies, and all the felonies are dismissed for whatever reason, and only misdemeanors are remaining, the court could just transfer it down to a lower court that hears misdemeanors. That's not forum nonconveniens. Forum nonconveniens is where a court finds it should be heard in a different court that it can't simply transfer the case to. Anyway, that's a very high-level view of it. Obviously, Aaron McQueen was talking about the, what's that guy's name? Brandon Pierce, Ethics Instead. He was talking about Ethics Instead's case. Ethics Instead's case, the court has subject matter jurisdiction, and because he is there, the court has personal jurisdiction. So when McQueen or Aaron Queen says that the court has jurisdiction because the court has jurisdiction, simple, trying to be ironic, but really just showing he doesn't know what the fuck he's talking about. Yeah, the court has jurisdiction because the subject matter is properly before the court, and ethics instead doesn't have any comprehension of how to even argue subject matter jurisdiction. Not that there is anything to argue. And the court has personal jurisdiction over him because he's there. He's literally there. and he was probably given a citation to appear or some other such nonsense, which would also effectuate service on him. So the court has personal jurisdiction. The court has subject matter jurisdiction. There's really no argument to be made there, which is why what I like to call real lawyers, generally speaking, it's very rare, especially in a criminal matter, that you argue jurisdiction, whereas sovereign citizens argue it all the time because they don't understand it. It is a very simple thing, and I'm sorry I can't use smaller words to explain it to people like Aaron Queen. He's just going to have to go through the rest of his life being stupid and not understanding things. Anyway, that's all I got for you today. Thanks for watching. Have a nice day.